Hello guys, hope you have learned section 92 entirely, right? You have cleared your, you have understood that section 92 clearly, fundamentally. Now guys, in case if you have doubts which are not subjective, now let me put it this way. There can be two types of questions, that is first is question of law and the second is question of fact. Now, a question of law can arise if there are, there can be two interpretations. So, we can discuss such type of doubts, but we don't want to get into the question of facts, which particularly deals with case to case scenario. So, in case you have such doubts, we have Telegram community also. You can post your queries there, or in a weekly meetup, we can discuss such doubts which may revolve around section 92. I hope that clarifies. Now guys, we'll move ahead to section 92A, where I'm sharing the mind map and where we'll be understanding the meaning and key aspects or key controversies which revolves around 92A. I'm just sharing the mind map. Now guys, as you can see, section 92A, we have covered two areas here. First, we need to understand the meaning as also key aspects of section 92A. And there are key controversies also under section 92A which are open every time and which we will be discussing today. So when you go ahead with the meaning, now section 92A has been divided predominantly into two parts. First part says that, the gist of first part is that it says that if an enterprise participates in the management, control or capital of other enterprise, then they are deemed to be, they are considered as an associated enterprises. Let me show you that by way of chart. Now guys, if you can just see here, section 92A. So this is basically my presentation only, which I have not taken from somewhere else. This is my presentation, but I have just put it here only so that we don't have to rotate through many apps. So now, if you just see here, section 92A1 has been divided into further two parts. Like, I'll just read that. An associated enterprise in relation to another enterprise, right? We saw the definition of enterprise under 92F, right? Under the definitions part. Now, an associated enterprise in relation to another enterprise means an enterprise which participates directly or indirectly or through one or more intermediaries in management, control or capital of other enterprise. Simple to understand. So I have given example here where there are three entities. First is ICO, whose parent entity is PICO, and the ultimate holding entity whose PICO's parent, which is HCO. So in this scenario, where an entity like HCO or PICO participates in management, control or capital, correct? Then this all entities become AEs of ICO, that is HCO and PICO becomes the associated enterprise of ICO, and vis-a-vis ICO becomes the associated enterprise of HCO and PICO, and HCO and PICO are also associated enterprise. Now this is what subsection 1 subclause A says. Now we just move to subclause B. What it says, that an enterprise in respect of which one or more person who participates directly or indirectly through one or more intermediaries, which is similar to the prior clause, in its management, control or capital are the same person who participate directly or indirectly or through one or more intermediaries in the management, control or capital of the other enterprise, right? So this also captures the situations where there is no direct or indirect holding with the taxpayer assessee, but there is indirect way they are associated with the taxpayer assessee. Now, if you can see in previous example, we arrived at a situation where HCO and PICO were considered as associated enterprise of ICO. That is fine. But now, in case HCO is also holding some investments in ACO, and ACO is also holding some investments in BCO, then technically the BCO and ICO also are called related parties, or let me put it down that they are also called as associated enterprises. Now this type of structure, so you should always check that whether the relation between two entities is also if this type of or not. Generally we see in big multinational groups, they have do this part where they have multiple brands in multiple companies. Now let me just give you an example. If there's a brand call XYZ who is into apparel business, and under the apparel you may see that many companies have different brands, and they run different SUVs or SPVs for running that brand, right? Now if there's a entity of one brand who's dealing with the entity of the other brand which belongs to a same parent company, then also the transfer pricing will be applicable on that particular transaction between these two different entities. You can see from that perspective and you can understand that part. Now I'll just move ahead. Now there is also subsection 2 which we call deemed A's. Now the capital control management itself has not been defined under the act, and that is what the controversy is all about. But to clarify further, the income tax department has also extended that definition by inserting subsection 2 which we call as deemed A's. What are that situations where the two enterprises becomes the associate enterprise? If you can see here, I have just basis my understanding of 92A2, I have bucketed them into certain parts, that is capital based, control based, management based and activity based relationships, right? Now if you see here, there are 13 situations from which a relationship can be emanated. So first is, as we know commonly, it's due to voting power, that is 26% holding of equity in directly or indirect way. Then there is capital base. Number 2 is substantial lender. So if an enterprise who has given the loan which is not less than 51%, the value of that loan is not less than 51% of the book value of the total assets of other enterprise, then these two enterprises can be also considered as an associated enterprise. This may happen, this may also give you arise doubts. Now let me just also clarify here a practical example. If there is a bank and it has given me a loan which is more than, so the value or the amount of that loan is more than the book value of total assets, 51% of total assets, then my friend, the transaction with that bank will be required to be reported under form 3CB. This is a conservative position, right, which I am taking. Even if your transaction, it would be at arm's length because you could not be directly related with the bank, but in this scenario you will have to report that transaction as you are covered under this definition of associated enterprises. Given the fact the bank should be outside, there should be bank should be a non-resident bank, not a resident bank, and the transaction between should not be between two residents. That's a fundamental criteria. But if you have taken a loan from overseas bank, if the entity has taken a loan from overseas bank and the value of that loan exceeds 51% of the book value of assets of that entity, then my friend, you should report that transaction under form 3CB. That is what my position is. There could be different views, there could be different concepts of different consultants, but I would always get into a conservative scenario. Then after we come to a minority holding in a firm, that is AOP or BOI, which says that holding not less than 10% or interest in such entities. So this is also a capital based scenario where there's a minority holding in a firm AOP or BOI. So for firms it's 10% basically, and for equity shares as such it's 26% for this other corporate firms, but for firm AOP or BOI there's this 10% criteria. Now we go to control base. Now so capital base was this, like you are making funding. Now control is when you are controlling by way of like see, if you see this, if there's an individual control, if there are guarantees which are given to that by one enterprise to the other enterprise, or there's an HUF or member relative of control entities, or there's a mutual relationship. Now here if you can see that in case even a person exercises individual control, and that could be categorized under 92A2, right? So these are all control based relationships. We might we might not frequently see such type of scenarios because most of times I have seen capital based the enterprises get covered. But yes, in my career I have also seen the activity based relationship. I'll just come to that. Then we come to management based relationship, which is appointing of board. Even though I may not hold, so entity may not hold share capital, but if it has a power to change the board of director, and more than 50%, so it has a power to manage the board of directors more than 50%, then also you can say that it's a management based relationship, and that is where the enterprise can be, the other enterprises to which this enterprise have a hold can be associated enterprises. Please don't forget that enterprise also includes the term person, which includes individuals as well. All right. And we move to the fourth part, which is activity based relationship. That means wherein the entire set is dependent on some activity which is being done by the other enterprise. This is possible in certain manufacturing scenarios or even IT development scenarios as well. Now I'm just explaining that dependency on intangibles. Now manufacture or processing of goods or articles or business is wholly dependent on that intangibles. So there could be a know-how or transfer of know-how or technical knowledge or brand. If your activity is totally dependent on that know-how, then also even though the other enterprise who is providing the know-how is not holding any shares or holding or does not have power in management, but still activity they are providing that know-how, and on basis of that know-how, if you are manufacturing that article. Now let me just also tell you, it is not like that if you are taking if you are just making payment of royalty, or if you have availed that know-how from the other entity and still you have to benchmark that. No, it's not like that. But if that without that particular know-how you cannot produce that, you cannot manufacture that product, then my friend, you are dependent, your product is, or your sales are, or your operations are dependent on the know-how of that particular enterprise which is being provided by that enterprise. You need to be cautious in assessing such type of things, and appropriately you should decide that whether they can be considered as associated enterprise or not. The department or the provisions say like that, in case if your production is entirely dependent on that particular intangible or say know-how, then the relationship between two enterprises would be associated enterprise. Then again, supply dependency. Now if you are dependent, or if you are if your raw material, if you are procuring 90% or more raw material from the other entity, and if your supply is entirely dependent on that party, then also there is a relationship which is covered under this specific provision of 9280 A2. And again, same with the sales. If you are only making sales with one entity, or probably if an enterprise can influence your sale value, then that enterprise can be considered as an associated enterprise. Now let me also clarify here, we have to be very practical when we are dealing with such type of activity based scenarios. Now let me just tell you also one example which I faced in my career. What happened, that there was a tire manufacturing brand which is an international brand. They wanted to set up a joint venture with an Indian group, right? Now Indian group and that overseas group were two different groups, right? They were not related groups, but they wanted to get into the joint venture part. So an advisory query came to us that, so guys, a query came to us that whether the transaction between this overseas group and the JV company could be considered as an transaction between two associated enterprises or not. If I'm mentioning H group, means basically the entity of that particular group. So if it is providing the technical know-how on which this JV company, basis which the JV company will manufacture its tires. So the advisory was on that part. And however, there was no direct holding of H group under JV company, but as JV company was entirely dependent on the know-how, manufacturing know-how of the H group, and that is where we arrived at the conclusion that this JV company and the entity of the H group company who is providing that know-how or who holds that know-how, there will be associated enterprise, or there will be a relationship between these two entities, and appropriately, even though there is no capital control or even management relationship, but this due to this activity, or probably you can say the control part also, not control but the activity part, there was this relationship between H group companies, that particular entity, and this JV company. So it's not every time this has to be applied, but you need to understand that in case due to that knowledge transfer, if they are not able to produce them or manufacture, that particular product, then in obvious case there is a relationship which can influence the price. So influencing needs to be understood. Now we'll just move ahead. I hope this clarifies. Now, there are some key controversies under section 92A which are very famous, which are very famous, and which are, there have been more debates surrounding those controversies. Why I am telling that they are controversies? Because there is no favorable part or unfavorable part. It has both sides rulings from various courts. Let me tell you that controversies. So under section 92A1, the act nowhere specifically defines the term capital control and management, which are at the core of establishing a relationship between two enterprises. As we discussed, that terms capital control management have not itself been defined under the act, and that is where you have to be commercially prudent to understand that whether that particular relationship influences the prices or not. Prices means the transfer price between the transaction which has happened or which is going to happen between two entities. Then the second controversy is on interplay of subsection 1 and subsection 2 of section 92A. That is whether both are to be applied jointly or whether both are to be applied independently. Now courts have taken different views every time. Some courts have taken view that 92A1 and 92A2 both have to be read together so that you can arrive at a conclusion whether the enterprises are associated or not. And some of the courts have just relied on the capital control and management part, and they have ignored 92A2 and on basis of 92A1 they have justified that there exists an association between two enterprises. Even the OECD does not define capital control management, but it provides guidance on that part. But we are not getting into that part right now. But this is the controversy between 92A1 and 92A2. Now, there is also controversy which revolves around timing of association between two distinct enterprises. So, as per the provision, two enterprises shall be deemed to be associated enterprises if at any time during the previous year. Now, let me just give you a practical example over here, which is also a case study. I have not mentioned that case study, but there was this case. So where there was one group right now, so that there was one company which was listed on Indian Stock Exchange. Now there was an agreement between the substantial shareholders of that company, the promoter shareholders, to transfer the stake which was more than 26% to the other corporate group, which was not related to them previously, right? What happened? That when they transferred that stake, which was again the other party was the other group was overseas group. Now, when they transferred this stake during the year of more than 26% to the other group, which was based on overseas, right? They, on a conservative basis, they reported this transaction under form number 3CB, and the case was, then the transfer pricing officer took up this case and he adjusted the purchase price or sale price of that share, at whatever the price the shares were sold between the shares were transferred between the parties. The assessing officer or the transfer pricing officer made adjustment to that, and post that it was the litigation scenario. Now the court held that there existed the relationship between these two groups because in a span of only 1 year, the one group exited 26% while the other group acquired 26% and more stake in that particular entity. So that's where timing of association came into play, that the court ruled basically. I'll mention it afterwards in the link, that particular ruling. You should understand that ruling. It's an interesting ruling, Palmer Investments ruling. So the court arrived at a position that there is an association between two enterprises as due to they are holding more stake at any time during the year. So if one group has exited during the year and the other group has entered into that company during the year, then these two groups becomes an associated enterprises. And groups are basically the entities, or this two becomes an associated enterprise, and hence that transaction was required to be benchmarked at arm's length. Now that is where the controversy regarding the timing of association lies. Now we come to the fourth part, which is Specific transactions such as loans, guarantee or dependence on know-how, etc. Yes, take conservative positions. As I always said that in case of activity-based relationship or in case of such transaction where there is involvement of only loan and no equity or no other such things, or this guarantee type of transactions, or even in such scenarios where this I spoke the previous part, that where two groups were different but one group exited from one entity and the other group entered into the other entity with a 26% or more stake. So that is where in such type of scenarios you should always take a conservative positions, have your backups, have your analysis done, so that you don't have to struggle when the litigation happens. Alright, so this was all section 92A about, guys. I'll move on to the next video, section 92B. If you have any doubts or comments, please post that in Telegram group, or we can discuss that in the weekly meeting. Hope you got learning out of the thing. Enjoy learning and relax and take it easy. I'll meet you in next video. Thank you.